Let item number 48 and 49 of your lordship's monthly list, my lord. Motion, my lord. Give some preference, my lord. Urgency is that, my lord. Group D recruitment. The petitioner got higher marks than the appointed candidate. Earlier, it is reached before your lordship.
On Monday, please.
Monday.
Monday, you mentioned.
Yes, yes. Okay.
Lordship, item number 94 from the monthly list, Lordship. The matter pertains to compassionate appointment of the petitioner. Earlier, he was facing problem because his elder brother was not willing to give the no objection certificate, but right now he has given it, Lordship. So if your Lordship kindly fixes any day.
He has given.
Yes, Lordship.
Then no dispute remains.
Lordship, the Union of India is not willing to give, Lordship. So it is to be decided.
This was the ground on which they were not
Yes,
considering.
Lordship.
So have you placed the no objection by way of supplementary?
Yes, Lordship.
Is he a party to the proceeding?
The elder brother?
Yes.
Lordship.
He is also appearing.
Yes, Lordship.
It is at which serial?
94.
Place it up, it will be disposed of. It can be disposed of.
Grateful, Lordship.
It is arising out of a writ petition. Which day it will come? Monday, you ask the lawyer who represents the brother also to be present.
On Monday, Lordship.
Monday, Tuesday, whenever you think.
Tuesday, Lordship.
Tuesday.
Grateful, Lordship.
That slip is dated. Slip is dated. She has given a date on the slip. Yes. Tuesday. Call. Call the list. No, it is not today. Don't call. Item number 2.
Three applications.
In item 2.
Item number 2.
Yes, what are the applications for?
A group of applications your lordship have already disposed of yesterday. These are the three which could not be filed in time according to the presentation form.
Where is your adversary?
One of the applications.
Where is your adversary?
Oh no, it could not be served because while it was going to be filed on in the department did not accept it because the date that was given on the presentation form has expired. Therefore, the department did not accept it. Or GP refused to accept it. So that is why they said that unless an extension is made on the presentation form, it will not be accepted.
I don't know the system. Can you please enlighten me? What is this system? Who gives the date on the presentation form?
On the presentation.
Yes.
And on the presentation.
Who gives that date?
We give.
You give.
Yeah. We give the presentation form.
The lawyer, the learned advocate who
we
files.
have to serve it. Before that, we have to serve it. So after the presentation form, we wanted to serve it. They said, on the presentation form, you have given a date something and you are serving it after that date. Therefore, I am not going to accept it.
Then why a court's order is required if it is a date given by the learned advocate who is filing it?
Yes.
Why?
It is filed.
So you serve, will direct the 3 applications.
Yes, 3 applications.
Let copies be served on the learned
Item number 3. Item number 3.
No, he has not even seen it. I don't think he has filed a can for condemnation also. What it is.
None appears on behalf of the
May I interject for once, my lord? I apologize for this. My lord, item number 1.
Call the list. Please look at the list, sir.
Yes,
Please,
my lord, I
please look at the list. Yes. We are
Great.
saying for a reason.
Item number 4.
Here on behalf of the Appellants Union of India, Mr. Lordship. On the previous occasion, your Lordship has directed that was our prerogative that since the notice has not been effectively, it was served, but in the noting it was mentioned that it was not served to the addressee. Therefore, it was Lordship is directed that whether it was served upon the appellant or not, or the respondent or not, to ascertain that. Lordship, may I be permitted file this receipt sheet procured from the postal department, Lordship.
Which serial?
Serial number 1, Lordship. The top
12.
12, Lordship. It was served upon Rinder Singh. And there has been a short sign. Lordship. It is also evident from my affidavit service, Lordship.
You have filed an affidavit.
Lordship, I have on the previous occasion I have already filed my affidavit service. From where, Lordship, the EW number would be evident, Lordship.
No, so you should place this on record.
Lordship, I have,
File a one-page affidavit.
Lordship,
File a supplementary to the earlier
Lordship, certainly, Lordship.
with the learned advocate submits. Wait to give it to give this back.
Item number 5.
5 I appear for the appellant, my lord. When the matter was last taken up, my lord, there was a direction for exchanging of affidavits, my lord. The respondents have not filed their affidavit in
You are for the respondent. Yes, sir.
For 1 week accommodation for filing our
1 week for what?
Filing our affidavit in opposition.
The learned advocate for the respondent.
Item number 6. My lord, 6, my lord, I am for the affidavit petition.
I am playing for the first time.
Let it.
I am not prepared.
My lord, my affidavit of service may be kept with the record. My lord.
You mentioned this matter.
Yes.
A prayer is made for adjournment. Affidavit of service. You filed an affidavit. Affidavit of service taken on.
Item number 7.
Plus 7, I am for the appellant.
Yes.
I am for the appellant.
Is for the other side.
Hello, Mr. Tom Bosak is for the other side.
What to do?
Next Tuesday.
Tuesday.
Next Friday.
Not today, it will come.
Today,
Not today.
Not-
Yes.
Item number 8. Item number 8 and 9. The 8 and 9
Yes.
are my appeals, my lord. I had argued the matter, my lord, with regard to appointment of data entry operators, where the honorable single judge has held that one set of contractual cannot be replaced by another set. And I had given a chart showing the qualitative difference between the two set of data entry operators, my lord. My lord, the appellants had completed the argument. The respondent writ petitioners were to give reply.
Yes, Milord, I only, Milord, seek today, I am in difficulty. Milord, if your lordship kindly allows me to address your lordship, because the other sets of counsel are here, because they are representing the other sets of respondent, contradicting, Milord, Mr. Bandopadhyay's argument. If I may take a chance, Milord, in the next Friday, subject to convenience of your lordships. Because
I have no objection to it, but I'll only remind Mr. Basu that the last adjournment was also on his ground. I'm not objecting to it. I'm only reminding him. my lord.
You remember?
this is a different, this is a unique kind of, Milord,
You remember?
trying to prejudice the minds of.
He's reminding you, so you remember.
Yes, I remember. Milord, I learned from him how to try. It's an effort, Milord, unique effort to try to prejudice the minds of the honorable judges, Milord. But it's
You think it is so easy?
And it is so quick.
You think it is so easy?
No, I don't think. But it is. I say no. That
As
is my
prayed-
conscious choice, Milord. That I said trying.
As
effort.
paid by the learned advocate for the respondent. Yes, sir.
Grateful, my lord.
Item number 10,
Could I appear for the appellant?
Yes, sir.
There is an application under section 5 of the limitation.
How much delay?
It's calculated as 43 days, but Lord, I really don't know how much the department has. It should be less than 43 according to my calculation.
Forty-one days. Yes. So the respondents are all represented.
There's only one respondent.
There's only one respondent. So that can, which is the can?
Can is Lord, can number 1.
Perhaps two.
What?
One.
Section 5 is can number 1, Lord. I'm told I may be wrong.
Can one doesn't
I
look
think
like it. It's quite a voluminous.
It's a thin application. It can't be Lord.
Yes.
I think the main
One is for stay.
then 2 Lord should be. And the certified copy was received on 18th of July. Applied for on 21st May. And then Lord, these are the procedural. Paragraph 12 onwards, if you like.
Very well. You have served. You have received. Heard the learned senior advocates.
Takes Lord can 1. Lord, I was wondering, Lord, if we can come back next Tuesday or Wednesday, if that is permissible.
Give a date when you can both.
Wednesday, Lord.
As joint Wednesday. As
I am sure my learned friend will.
he has said enough.
I tell your lordship why I took the point, took time, because Lord, I seriously want to apply my mind. This is, Lord, raises a very interesting point of law.
What is it?
The issue is that an employee of the bank, certain misconduct was found post his retirement. Lord, majority of the loan that he has sanctioned, these companies have, Lord, these loan accounts have gone bad, in the sense that they were declared, Lord,
NPA.
NPA. Now, Lord, the issue is that of recovery. Now, Lord, a proceedings was initiated for recovery of the amount. The learned judge has allowed the writ petition principally on the ground that post-retirement, there is no provision in the rules for initiation of proceedings, disciplinary proceedings.
Yes, once the master-servant relationship snaps.
But Lord, there are two regulations by which the bank is guided. One is the pension regulation. The pension regulation says that in case there is any financial loss suffered by the employer, then Lord, certain percentage of the pension can be withheld. His gratuity and Lord, his provident fund, his contribution has been released. So this is Lord the stage where we are. Lord, I am just Lord, I want to test Lord the pension regulation, whether it can stand alone. Because Lord, under the pension regulation also, it says that you will have to initiate some kind of a proceedings for the purpose of retaining that portion of the pension. A portion of the pension has been retained by the disciplinary authority. I just want to come back.
Normally, under such rules and regulations, there is a provision which says that a proceeding can be initiated for the limited purpose of the pension rules, but provided it is initiated while he was in service, or there is normally a time frame of about 4 years in almost all the rules, that if the event relates to a period beyond 4 years, it will not be permissible. That is normally seen in.
That is taking into consideration the period of limitation, because after all, this is a claim of our money.
That's a very standard provision.
I have to closely look into these regulations. I didn't really apply my mind to this. That's the reason I took time. I just thought I'll apprise you.
Mr. Majumdar, on 11th, you just. Yes.
13th, Lord.
No, on 11th, he will. Oh. There is a contempt. You said it is coming up on 11th. Yes.
Much okay. Much okay.
We shall not proceed.
Item number 11.
Mr. Devdatta Basu is appearing for the petitioner. He is engaged before court number 38. I am praying for not to Lordship.
Lordship, I am appearing on behalf of NBSTC, Lordship.
Hmm?
I am appearing on behalf of North Bengal State Transport Corporation, Lordship. Yesterday evening, I just get the appointment. Till now, I did not get any copy of brief and also instruction. Kindly give Lordship 7 days accommodation. Kindly, Lordship.
The learned advocate for the
Item number 12.
yes. Sorry. Yes.
My application on behalf of the Union of India, specifically Department CISF. Lordship, there is a delay of 76 days, minutes. But initially, Millard, that delay needs to be condoned subject to whatever falls from my laws.
Can number?
My Lord, can number 1.
You have served a copy.
Lordship, my Lord, I am today slightly handicapped because the
You have copy. 71 days.
76
What is the reason assigned?
Lordship, we have assigned the reasons, Millard. Some is, Millard, at page 3, Millard, paragraph 3 and its subparagraph, we have categorically tried to explain each and every day's delay, Lordship. Most of it is because of the various buffers which we have to cross for preferring an appeal, because there is a lot of particular standard operation procedure which we follow. But my lord, this much I can, my lord, assure your lordships with deepest of respect, my lord, that we have a very bright arguable case, my lord. My lord, if some benevolence is shown by your lordships, then my lord, we can come on merits of the case, my lord, whenever my lords deem fit and proper.
You said 71 days.
76 lordships will kindly come to my prayer, which starts at page 5, my lord, and concludes at page 6. That is the penultimate, my lord. Condone the delay of 76 days, lordship.
You need to file a supplementary to the CAN application. Just check the number of days from the
My lord,
report.
then in that case, my lord, because
Complete that process.
lordship, I shall.
The Leonard,
I'm grateful, lordships. Just act me.
Item number 13.
I'm appealing for the respondents.
Yes, sir.
some prayer was being made.
Lord, I've joined.
How are you now?
Lord, certain restrictions are very slowly I'm moving. Lord, I am not allowed to rush through courts.
But you should not.
Stay put.
Last 2-3 weeks it is being adjourned, therefore we asked. Yes.
But only one thing I just tell you, Lordship, this is an appeal against refusal of interim order with direction to file affidavits. We have used our affidavits. My learned friend's advocate on record has not accepted till the has not yet accepted because dependency of this appeal. My humble prayer first, subject to my learned friend's submission, take the affidavit in opposition and request the learned single judge immediately hear out the main writ petition. That I think solves the problem. This is against the refusal of interim.
Why you are appearing before the Red Court also? Then why are you not accepting the
Lord,
copy?
I was not there for 2 weeks. I don't know what my handwork copy.
This is not.
We shall take a copy, my lord. That's not a problem. But my lord, in that event, if my lord fixes a time in the writ court to dispose it of, my lord,
Never.
No, you
I'll be the last. I'll be the last person to do that.
Make a request, your lordship.
You make a mention why it will not be done. Once you may be required to file a reply.
Well, all the honorable single judges are highly praised.
Sir, it's very
Determination
difficult.
kind level
Now
look
that
at
the
it.
mic is off. Why we don't fix a time? Just see
Yeah,
that
yeah.
last 3 weeks, what mentioning is being made on his behalf. Who can foresee such eventualities? It's a question of fixing a date. The court is hard pressed, it will deal with it according to priorities of the matter. As per merit. What is the matter substantially?
I tell you, lordship,
Then
what
my learned friend place.
what
I just
happens-
take your losses
Yes.
for 5 minutes and come.
What happens, my lord, here, my lord?
India authorities, my lord, issues as a public advertisement or press release saying calling for the departmental candidates to sit in written examination for their promotion by selecting them, like undergoing a selection process. Now, my lord, we applied through the paper publication, qualifying the eligibility criteria. My lord, initially, my lord, the authorities what they did, the first notification which they issued was cancelled. Thereafter, they again press release, my lord, further notification for the calling for the candidates. Now we again participate. Now, my lord, in that notification, they lay down the entire criteria, what marks will be allotted, how much marks will be allotted for qualified, semi-qualified candidates. Now, my lord, pursuant to that, we apply, we are in finance department. The petitioners are in respect of finance department. Now, my lord, subsequently, my lord, my lord, after calling for the written examination, which was scheduled on 29th of November, my lord, 24th of February, in midst of that, my lord, they issue a notification saying HR manual clause 1.15 would be applying. Now, my lord, to that we make our representation. You cannot apply in the midst of the game when all participants have participated. Looking at the criteria set down in the press release, now you suddenly cannot say that this rule would apply. Now, my lord, even for sake of argument, my lord, I try to make in my submission that even for sake of, if we look to the HR manual even, my lord, HR manual cannot be isolatedly looked into. It has to be looked into in its entirety. My lord, 1.15 in my humble submission is a criteria which says that one has to keep reserve, my lord, within the qualified and semi-qualified. My lord, what is that reservation? For departmental promotion, my lord, they say you have to give 20% reservation, 15% for qualified, 5% for semi-qualified. Now, my lord, this reservation is amongst the total reservation of 100%. So, my lord, 80% direct recruitment, 20% divided 15/5. Now, my lord, in the press release which they say, they allot 10% for the additional marks for these qualified candidates. So, my lord, if they allot 10 marks, my lord, for qualified, we being semi-qualified, we are already in disadvantageous position. We are in the rule of the game now. It has started. We give our written examination. Now, my lord, suddenly additional 15% reservation with additional 10% already allocated. My lord, is something, my lord, prejudicial or double benefit is being given. Now, my lord, had it been a came from the initially we knew we participated, it's something else. But in midst, my lord, when everything is done, then, my lord, suddenly this application, my lord, in my humble submission is changing the rule of the game in the middle of the show. Now, my lord, in this perspective, my lord, I pray, my lord, for the timing till disposal of the writ petition, kindly do not make this rule applicable or stay let this 1.5 not be made applied to. My lord, this was my interim prayer. Now, my lord, another thing, my lord, in the HR manual I would show, my lord. আচ্ছা আচ্ছা আমার বলছিল কবে তো না
The liberty at paragraph 8.
Yes, my lord, I've seen, my lord.
What is, we don't even have to ask to expedite.
My lord, only
The
thing,
court
my lord,
has
the
already.
paragraph 6. my lord, which refuses my interim order only
That
on
is
that.
over now. That is over now.
My lord, today, if I do not get the interim order, they choose, my lord, person as giving.
Then
this
you
result.
file a reply, then we'll see. You take the opposition, you file a
Here,
reply.
I can take it, my lord. I've just taken instruction. My lord, what happened? He left the court on that particular day. He left for yesterday, my lord, for hospital. Yesterday, it was only tried to be served. My lord, today he can take it. He left it.
Take a copy. Appear before the single judge. Get the matter expedited.
Kindly fixes a period, my lord, I have no problem. My lord,
We will
otherwise, my
not,
lord,
we have said very clearly, we are not going to fix a time for any court to conclude a process, let alone a single bench of the High Court.
Then what happens, my lord, what I am apprehending today, if this prima facie, if I can show from the HR manual as well as the, my lord, press release, that this 1.5 will not apply.
Let us see 1.5.
Kindly takes up.
What is the change introduced?
Yes, my lord, kindly takes up, my lord,
You
my.
filed the opposition. Oh, here there is no opposition.
No, here there is no opposition. There is no
Then how can we consider?
opposition, my lord.
Then let them file an opposition here. Then we'll consider. It is up to you.
This is something very apparent from the documents already on record. I will rely upon the HR manual, my press release, nothing more. If my lord is satisfied that because one line that
We are,
doesn't
in
say-
effect, we will be finally deciding the matter at the interim stage. What you are requesting us to do will amount to a final adjudication at the interim stage.
But prima facie, my lord, today in any case, my lord, when I am seeking for an interim order, my lord, I have to satisfy.
You
my-
are seeking stay of the provision which you are feeling offended by. So that amounts to the final relief at the interim stage.
Then, my lord, then I can mold the relief to the extent of not to fill up the vacancies till the.
We don't find any such prayer made before the single judge. Who
Then
stopped you from making that prayer?
Even otherwise, my lord, today, my lord, if
You did not make such a prayer, otherwise comes after that. There is no such prayer made by you before the single judge.
my lord, a notice comes to my hand.
Sir,
my lord,
we are
if
not
I
on
have-
supposition. We are on what the order says.
Absolutely, my lord, I am not.
You never made such a prayer.
No, I did not.
So
my
go
lord.
back, make that prayer. Who is stopping you?
Today, my lord, the prayer interim order which I have prayed, my lord, is limited to the giving, if not effect to that notification which has.
That is the ultimate relief you want in the writ petition. You want it by way of an interim relief.
Lord, I am under.
Now address us that such a relief can be granted at the interim stage, which is prayed for as the final relief. You show us the judgment.
1985 Calcutta. Mukto Keshi, my lord, knows, my lord, by heart.
We don't know. We only know what you show us.
85 Calcutta. Today I'm handicapped. Kindly gives you Monday, my lord, I will bring those Mukto Keshi and all the where at the interim stage I can pray, my lord, and interim relief which, my lord, is touching upon the final relief. Otherwise, if it is goes nugatory.
Touching upon and the same relief are two different things. That is precisely what we are telling you. You want stay of the very same provision which you are seeking to be declared as.
I'm entitled.
Yes.
I'm entitled. That's why I say, I'm entitled to. Otherwise, if these provisions are applied, people are.
That is why now the affidavit has been filed. It will be decided. What is there to stay?
Meantime, if they declare results and these results.
Participated in November. Till now, nothing has happened.
No, we gave our exams in November. Exam results.
That change was on 20. See, that change was on 24th. And you wrote the examination on 29th. After that change.
And my last date of submission was in March.
Whatever. After the change, you participated.
There was no change. A notification came out. There is no change in the
That
press.
is the notification. That is the notification by which you are offended.
With filing our objections.
You have filed your objection.
Yes,
on which date?
But we filed our objection. Date of birth. That was received on 17 December 2025.
So much after you participated in the exam.
Before that,
24th is the offending notification. 29th is the exam. In between, there was 5 days. We are not going to take any paper like that. We want you to show it from the writ record.
It's not there.
Then we will not. Why should we? We are not going to accept anything like that. Sorry.
File a supplementary.
No, we are not going to allow you.
24th November, there was a.
We are not going to allow you. These facts were not there. How it will invalidate the order?
My lord, even I say, my lord, even if it is
You
not.
go and show it to the judge.
No, my lord, even if it is not there, my lord,
Yes.
today I can pray for that interim order.
You cannot. The law is very well settled. If you have participated after that without an objection, then you cannot. You know the law very well. We need not tell you. That's why we asked you this question. We have seen these 2 dates. You have taken no steps. There were 5 days. A person who will be offended, but he will wait for 5 days.
He have issued, but it is not.
He don't know anything which is not there before the honorable single judge. How he will consider?
I can bring.
Go and make that prayer before under order 41 rule 27. Who is stopping you?
There, my lord, it may not.
That will not invalidate the order. Please try to understand. A fact which was not before the honorable single judge, he cannot be held for not holding that fact.
I will come back on Monday on 2 issues.
You want to keep here, then you can stay here. List after 1 week as prayed for.
But Monday, because I will only be showing judgments and my lord, one thing where from the manual it doesn't apply.
No, sir, we are not at all inclined on the basis of these facts which are there. We have asked you, we have heard you on the issue. If you had made out a case, we might have. We don't find any such case being made. It is submitted by the learned advocate for the respondent that
Item number 14.
I appear for the respondent numbers 2 and 3.
My lord, Advocate Bikash Chandra Nyogi is appearing in the matter. He could not be present for personal reason, my lord. I'm praying for not this week, my lord.
you are for the appellant.
Yes, my lord.
This was taken up earlier also.
Yes, my lord, your lordship had heard it. Then it was adjourned. My learned friends. Yeah, at that point of time.
When do you want?
My lord, 1 week time. 1 week time, my lord.
You have any offer? No. As prayed by the learned.